Well, hello, and welcome to this webinar on the timely subject of bail reform presented by the Daily Journal and Journal Technologies. I'm Lisa Rodriguez, a judge from San Diego County. I'm joined today by a distinguished panel of experts on bail and bail reform. San Francisco District Attorney Chesa Boudin, Executive Director of the American Bail Coalition, Jeff Clayton, the founder of the Bail Project, Robert Steinberg, Sacramento County Chief Probation Officer Seale, and a special guest from South Australia, Chief Magistrate Judge Mary-Louise Hribal, who is joining us from tomorrow to discuss bail and bail reform. Bail reform is a topic that's been addressed nationwide over the last several years, from minor legislative changes to overhauls of entire systems in states like New Jersey and New Mexico, from constructing local pretrial programs, locally ending cash bail in some jurisdictions, and founding nationwide initiatives, and you're going to hear about some of that today, to exploring the use of a wide variety of pretrial assessment tools. And that's generated questions about implicit bias and algorithms. Bail, bail reform, and preventative detention are topics that have been very much at the forefront of a national discussion on criminal justice. But before we dive into a discussion with our panelists about the current state of bail and bail reform, let me quickly set the stage. To do so, we have to go all the way back to 1215, to the Magna Carta. It was within the Magna Carta that the concept of bail was introduced. It was to ensure that people accused of crimes were not just held at the pleasure of the king. So for bailable offenses, there was a focus on the release of the accused, and a method to ensure appearance at trial, a surety, if you will. Either the accused or a neighbor assured the court that the accused would return. And so when the United States was formed, this was really the underpinning of our criminal justice system, this foundation of the presumption of innocence and the right to personal freedom. And so most states protected that right to bail through those same sufficient sureties, a promise to appear by you or someone on your behalf. Money wasn't a factor initially in release or detention. But as the country grew and it became easier to leave jurisdictions, money began to replace neighbors and bail schedules were introduced. And as the bail schedules increased and the cost of purchasing freedom prior to trial became more expensive, insurance carriers were encouraged to provide a vehicle for defendants to secure their release. So by the 19th century, the deposit of money or a pledge of assets had become the principal condition of release, and we had evolved to a commercial surety system. It wasn't until the Bail Act of 1966 that consideration of public safety became part of setting bail. And Congress in 1984 federally mandated pretrial release upon an unsecured bond unless such release would not reasonably secure the appearance of the person or would endanger public safety. And it also authorized pretrial detention. This was upheld in United States versus Salerno. In that case, the U.S. Supreme Court said, in our society, liberty is the norm, and detention prior to trial or without trial is the carefully limited exception. Yet across the nation, the pretrial population has increased dramatically as people remain in custody because they can't afford bail. Statewide, pre-COVID-19, about 60% of the county jail population was pretrial inmates. In fact, the pretrial population has grown at a faster pace than that of sentenced inmates, despite historically low crime rates. Moreover, it's widely reported that there are racial and gender disparities in the system. Statistics show that African American and Latino defendants are more likely to be detained pretrial than white defendants, and less likely to be able to post money bail as a condition of release. It's also widely reported that longer pretrial detention threatens employment, housing stability, childcare, access to healthcare, and disposition of cases. And so efforts have been pursued in both the federal and state court systems. In 2016, Chief Justice Tani Cantil-Sakayue and the California Judicial Council created a pretrial detention reform work group, and I was honored to serve as its co-chair. Our charge was to look at how courts could better identify ways to make release decisions that would treat people fairly, protect the public, and maximize court appearance. We learned about that history of bail, and we had presentations from over 40 groups, including victim rights groups, the ACLU, the American Bail Coalition, and jurisdictions that have decades of alternative bail system and some, including New Jersey and New Mexico, that were just at the beginning of their bail reform. The issues addressed were whether bail reform was needed, and in what way and to what extent. So I want to turn to our panelists now and ask them those very same questions. Do you believe the current bail system needs reform? And if so, in what way? What do you think the bail system should look like? So let me start first with our district attorney, Mr. Boudin.
Well, thank you very much, Judge. It's great to be here. And of course, thanks to the Daily Journal for bringing us together. The money bail issue and policy issues that your introduction implicated are near and dear to my heart. I've been working on these issues for many years in a variety of different capacities. And I'm proud to say that I think we are making a lot of progress. But let me start by answering the question you posited to me. The money bail system really is a cancer at the heart of America's criminal justice system. As soon as a wealthy person is arrested, they can buy their way out, almost without exception and without regard to how dangerous they are or how great a flight risk they may be. And they can then remain at liberty while they fight their case. An identically situated poor person, by contrast, languishes behind bars, even if no charges are even filed against them until that decision is made, simply because of their poverty and inability to make a monetary payment. Now, for context, let's remember how significant even a short period of incarceration can be on people's lives, on their future prospects. It's hard to overstate how serious the consequences of short-term, much less long-term incarceration can be for lives and for the outcome of particular criminal charges. That is, not only are people who are incarcerated pre-trial deprived of their liberty, but they're also exposed to violence, diseases like COVID-19, termination of employment, eviction, loss of child custody, and so much more. But they're also more likely to plead guilty, whether they are guilty or not, simply as a way to resolve their case and get out of jail. Now, pretrial detention has very severe consequences on people's ability to get jobs, to keep jobs. Medical care is disrupted, families are impacted, entire communities are impacted. And I say all this because we should not be making such weighty decisions based on wealth. We should be making decisions with these kinds of severe implications for a fundamental right, a right to liberty. That's one of the most fundamental rights in our system of government, in our Constitution. That right should only be interfered with after a criminal conviction or in the pretrial context when there is an overriding government interest to do so. And wealth-based discrimination is simply not a legitimate basis for depriving people of their fundamental rights. Now, it's also worth remembering that the commercial bail industry is a uniquely American phenomenon. Only the United States and the Philippines have a for-profit bail industry that has the power to decide who is incarcerated pre-trial while they're presumed innocent and who remains at liberty. It is a system that in many ways undermines the integrity of the entire criminal justice system. It's a $2 billion a year private for-profit industry, and it has been directly implicated in the dramatic expansion of pretrial detention from about 125,000 people on any given day back in the early 1980s to about 500,000 people today, people who are presumed innocent. Now, the legitimate goals of any pretrial release system should be to simultaneously maximize release of people who are presumed innocent, so we are upholding our commitment to liberty. 2, maximize public safety, so that we are protecting the public from people who may pose a risk. And 3, maximize court appearance, so that people are not fleeing or forgetting to come to court. Now, despite its widespread use, secured money bail fails to do any of those 3 things. It does not maximize release. It actually causes tremendous amounts of needless incarceration. It serves essentially no public safety function whatsoever. And it's not necessary to ensure court appearance, as tremendous amounts of experience around the country have shown. And just to wrap up, I will quote one federal court that addressed this issue under California law. And the federal judge wrote, quote, "There is no rational relationship between the setting of bail and the state's legitimate interests. Enough said. Thank you.
Thank you. And I'm going to come back and talk to you about the cash bail system in a moment. Bail Project founder Robin Steinberg, why don't you tell us your answer to that question?
Sure, and some of it's going to echo very strongly what District Attorney Boudin has said, but I will give it my own flavor here. Look, the power to take away liberty is one of the most extraordinary powers that we give government in this country, and it's one that comes with enormous responsibility. And quite frankly, we have shirked that responsibility in this context. And when it comes to cash bail, we have obliterated that responsibility. It's why bail reform is, in my opinion, one of the critical civil rights issues of today, and one that we really need to be addressing. Our jails are currently, our local jails are currently filled mostly with people who are there because they can't pay cash bail. And that is obviously disproportionately impacting low-income communities and communities of color. It affects about 2.5 million people every year. And on any given night, about 500,000 people are sleeping in jail cells across this country from one end to the next because they don't have enough money to pay their cash bail. So why do we need to have bail reform? First of all, it's built on a myth. So cash bail is built completely on a myth. And in turn, the bail bond industry is built upon a myth as well, which is we created an entire system on the idea that money is what will create an incentive for people to come back to court, or property will create that incentive. It turns out, certainly from the work that we've done at the Bail Project and the work that I did prior at the Bronx Freedom Fund in New York for 10 years, where we collected data about what happened when we used philanthropic dollars to pay somebody's cash bail and they don't have any money on the line. What we saw in New York City was that 95% of our clients came back to court. What we see nationally now at the Bail Project in the 23 sites that we operate from one end of the country to the next is that clients make 91% of their court dates when they don't have any money on the line at all. So money was not the incentive, right, that was needed to make people come back to court. People simply come back to court because it's in their best interest to do so. It's a pretty simple equation, and there are lots of things we can do to ensure that those rates stay high. But the cash bail system needs to be reformed because it's built upon a myth. As DA Boudin also said, it creates a two-tier system of justice, one for the rich and one for everybody else. It has a disproportionate negative impact on low-income communities and communities of color in this country. It is a driver of racial disparities. It drives mass incarceration. It's responsible for 99% of jail growth over the past couple decades in this country. It literally leads to incarceration before conviction, which turns the presumption of innocence on its head and frankly undermines the credibility of our criminal legal system entirely. It leads people to plead guilty to crimes, whether they did them or they didn't do them, because it's the only way to get home to safety and back to your family and to your loved ones and to your community. It is unfair, it is unjust, and it's unnecessary. And it's wildly costly, not just to the people who are held in those jail cells and to their families and their loved ones, but also to their communities and to the American taxpayers who foot a $14 billion annual bill to hold people in jail cells who haven't been convicted of crimes. So cash bail needs to be eliminated. I think the question for all of us on this panel as a nation is what comes next, what comes after it, since I think it's been proven to be something that needs to be eliminated. And I would say, you know, in very brief, we can get into more details, but clearly release ought to be the presumption. People should be presumed eligible for release, not the opposite, which is what's happened with cash bail. Detention, pretrial detention should only be used in the rarest of circumstances and only after there has been a proceeding to determine whether it's necessary. And, you know, people always say, well, how will that get done? And I like to say, well, we built these massive courthouses with marble columns and lots of judges and stakeholders in those buildings to determine just those things, right? It shouldn't be a secret. It shouldn't be an algorithm. It shouldn't be determined by anything other than a transparent, open hearing where the government has the burden to prove that somebody may pose a risk to a particular person or community if they're released, and that there should be a high standard of proof before you take somebody's liberty away. If we could get that far, we will restore some of the legitimacy back to our criminal legal system. Of course, there are lots of other reforms that need to take place too, but with respect to cash bail, we could start there and we would take a big step forward.
Well, thank you very much. I think that is a great starting off point to turn to American Bail Coalition Executive Director, Jeff Clayton. Why don't you tell us your answer to that question?
Well, thanks everybody for having me. I'm just going to jump right in. I'd say the expansion of preventative detention policies since 1970 by eliminating the right to bail by sufficient sureties, the erosion of the presumption of innocence by attempting to predict future criminal behavior, and the state supervision of the presumed innocent is a flawed system that is embodied in California's new Senate Bill 10. I think the traditional right to bail is a better check on government power, regardless whether it works or not, to keep the government out of your business while you defend yourself, rather than expanding preventative detention policies, which must be stopped. And bail is a fundamental constitutional right in this country, and I think many states, such as California, have a more expansive guarantee that all prisoners shall be bailable by sufficient sureties except in very limited cases. And I think this is ultimately why the heart of Senate Bill 10 will be unconstitutional, that California's constitution specifically enumerates the cases and charges where bail can be denied, and the legislature lacks power to expand them. Almost a century ago in Leary versus United States, the US Supreme Court held that states could allow indemnity contracts for bail and choose to regulate them. And this is the right to the bail, which is included in the Eighth Amendment. And I would also point out that the right to bail by sufficient sureties in a world without generational mass incarceration coexisted quite well for generations until this grand experiment of dangerousness, preventative detention, and risk began in the 1960s. There should be indemnity contracts for bail because they create an economic incentive to decarcerate. The so-called in-cash bail debate is really about a simple thing. A bail that is not excessive under stack that serves to detain is something we don't like. And critics would call this sub rosa detention, which they say is no different than preventative detention. And our organization has fought preventative detention policies vigorously because the answer to too much incarceration is not more of it. If sub rosa detention is the problem, then why would we make legitimate the otherwise illegitimate by authorizing preventative detention? We wouldn't. We would find greater pathways to reduce sub rosa detention by release on bail, monetary or non-monetary, under sufficient sureties or excessive bail analysis. And I think the federal bail example proves this, that when there was a right to bail by sufficient sureties in 1983, there was a 24% pretrial detention rate. And when this was eliminated, it's now climbed to 72% today. And I think basing bail on future dangerousness erodes the presumption of innocence and is something that needs to change. In holding the Bail Reform Act of 1984 unconstitutional, United States Court of Appeals Judge Amalia Kearse wrote that the system of criminal justice contemplated by the Due Process Clause, indeed, by all of the criminal justice guarantees of the Bill of Rights, is a system of announcing in statutes of adequate clarity what conduct is prohibited and then invoking the penalties of the law against those who have committed crimes. The liberty protected under that system is premised on the accountability of free men and women for what they have done, not for what they may do. During the testimony of the Bail Reform Act of 1984, mental health experts and many others since have indicated that there is no scientific way to predict future dangerousness of a person. Today, however, we rely on instruments like the Arnold Foundation Public Safety Assessment, which uses group data and purports to be 72% accurate. Today, we assume dangerousness without question, when a generation ago, we would have said it to be nefarious. So I think it's time to go back to the future on bail reform. The ACLU was asked in 1984 what would be a better solution to the problem with pretrial detention, which would be to oppose preventative detention policies and support true speedy trial reform. I think California's Senate Bill 10 is fatally flawed, and I do agree it's time to go back to the drawing board, and I think bail should remain as a fundamental right. And we think our fourth generation of bail reform, which is on our website, is probably a more sensible way forward. So thanks again for having me. And as one bail bondsman famously told me, the reason that we're needed is because jail has a lot of bars, but the wrong kind.
Thank you very much. Let me turn to Lee Seale, who is the Chief Probation Officer of Sacramento County. They do have a pretrial program there. Tell us if you think the bail system needs reform, and if so, in what way?
One of us had to do it, right? So I want to first thank you for having me on this panel with our esteemed colleagues. It's a pleasure to be here and talk about this important subject. You know, I want to step back because you're hearing some good thinking from our panelists today about a very important subject, and it's topical for all of us to really put some time and energy into understanding this subject, because we have in front of us some ways in which this is going to come to the forefront. As Mr. Clayton suggested, voters are going to have an opportunity in November to weigh in on whether or not a law that was passed that would eliminate cash bail in California, whether or not that will take law. And this is a terribly important public safety and public policy question that's put before the California voters. And I think it's really incumbent on us to do what we can to understand how these processes work. And secondly, as we may talk about at some point today, we have some important litigation on the horizon as well in front of the California Supreme Court to take a very hard look at this very question as well. So I begin by saying those things as a way to suggest to all of us that it's really incumbent on us to begin with an understanding of how bail works. And you know, I've been in this system for working in this criminal justice system for 20 years and began as a criminal prosecutor and now as the chief of probation for Sacramento County. And it still surprises me to this day how much, in my view, is opaque about our status quo. For example, the premise of money bail, I think for many people, they believe it to be something in which a person posts bail. If they do what they're supposed to do, they come to court, they stay out of trouble, they get that money back. And for the vast majority of persons coming in front of the criminal justice system, that's simply not the way it works. In fact, what happens almost entirely, at least in Sacramento County, and I think this is true throughout California, is that defendants utilize commercial bail bonds. And the way this works is that typically a criminal defendant will pay some percentage of bail, sometimes 10%, sometimes a lesser amount. And that amount of money is forfeited no matter what the outcome of their future proceedings. So in other words, if they show up to trial and do everything they're supposed to do, they still lose that money. And to me, that's an important point to add to this, very good job of all of our speakers setting forth some of the components of the system. And that for me is a very telling reason why I am troubled personally by the use of cash bail in our criminal justice system. I should step back and make clear that I'm speaking just for myself. I'm not speaking on behalf of our county or any other persons in our local criminal justice system. But my view is that really not just cash bail, but I really believe that the criminal justice system should be doing everything it can to eliminate the role of money in general in the criminal justice system. I think it's often a conflict of interest for criminal justice agencies, and I think it has a very dangerous influence on decision-making. We can have a debate about the merits of SB 10, and Mr. Clayton raises some very worthwhile points to consider, including the use of risk assessments. And I think we'll talk about that in a moment. But, the threshold question before we get to what system should potentially replace money bail, my answer to the question of whether money bail should exist is no. We need to do something different.
Well, thank you very much. And we're going to come back and we are going to talk about assessments and supervision. But let me turn now to Chief Magistrate Mary-Louise Hribal. What is your system? What, as an outsider from the United States, what do you think of the bail reform?
Thank you very much for asking me to join you today. And sitting listening to you, it's obvious that your system is very, very different to the system we have. And so I might just sketch out for you a bit about what I'm from and what we do, and that will give you some context into some of the comments I'll make in relation to bail. So South Australia is a state with about 1.6 million people. I'm the Chief Magistrate of the Magistrates Court of South Australia, and that is the point of entry for all criminal matters that are going to proceed in this state. So we have about 60,000 lodgements a year. Some of them stay with us and finish with us, but some of them we perform an administrative function to see if there's sufficient evidence before we send them up to a high court. Examples of offences such as murder or rape or armed robbery, then they go up for trial or sentenced in a high court. But why that's relevant is because that means that every matter comes before us, and we're seeing people after they've been arrested coming out of custody, and we need to make a decision as to whether or not they're going to receive bail. So we're the first point of entry in relation to bail, and then there are several times during the process before we send them up to the high courts, if that's where they're headed, where people continue to make bail applications because their circumstances might change, and so we need to reconsider the issue of bail. So we have about 3,000 people in jail at any one time in the state. Of that number, about 22% of them identify as being Aboriginal, and 42% of the people in jail at any one time are on remand. So they are people who haven't been sentenced. But they're on remand, most of those people, for a very short time. It might only be 2 weeks, and that's because of the way we deal with bail. We rarely use cash bail. I was trying to find some statistics as to how many cash sureties we're currently holding in this state, and my people struggle to even find that. There's about 100 at the moment, cash sureties. It's a very unusual sort of order for a judge or a magistrate to make in relation to bail. And it's usually, I'd have to say that if you're thinking of not granting someone bail and cash is offered, it's probably not enough to make you change your mind. So we have similar considerations to you in relation to bail. We need to look at whether someone's likely to return to court if they're bailed, the risk of reoffending, and protecting the complainant and the community. In more recent times, there's been a bit of a trend towards something called prescribed applicants. So there are some offences where the presumption in favour of bail has been reversed, and it is the defendant who has to establish that special circumstances exist. An example of that sort of offence would be choking or strangulation in the context of domestic violence, and we're seeing a number of those before the court. Doesn't mean those people won't get bail, but they need to establish that there are special circumstances. In 1987, we introduced home detention bail to South Australia, and that's what you'd know as sort of anklet bail, and that has really been transformational. As a result of that, a significant people who are charged with major indictable type offending are now given bail, and so the matter comes before the court. A report is ordered by the magistrate or judicial officer as to both the person's suitability for home detention and also the suitability of the place where they would reside. And so as a result of that, there is a lot more people who probably wouldn't have been able to obtain bail, and so it's been very successful. I'm told by our corrections that about over 40% of people who are on home detention bail manage to successfully complete their bail obligation on home detention bail. And so that system is working reasonably well. So the major probably impediment for our people to receive bail would be lack of a suitable address. And so if you're homeless, obviously you're not likely to have a place where you're going to be able to do bail if you're someone who's been couch surfing and trying to find somewhere. So there was a bail hostel that was established here in South Australia, and that has assisted people who would otherwise not be able to proffer an address for home detention bail. So cash bail is something we managed to just about exclusively do without. In fact, if as I said, if someone's offering their title deeds of their house or they're offering cash, you might be fairly cynical here and think that if they're able to come up with the cash or they're able to come up with title deeds, you mightn't see them again, and it might be something that concerns you more than not. So that's a bit of a snapshot of what we're doing here.
Well, thank you very much. Let me turn really to talk a little bit more about the role of cash and bail. District Attorney Boudin, you came into office this year in 2020 and immediately declared San Francisco was eliminating cash bail. Tell us what you've done in San Francisco and why and how it's been working out.
But, as you heard from all the other speakers, the bottom line is wealth and money should not play any role in a system of pretrial detention. When we presume people to be innocent and when we recognize liberty as a fundamental right, we should only deprive people of that liberty when public safety or some other compelling government interest requires. And their ability to come up with a monetary payment, as I think it seems to be the consensus in Australia and probably the rest of the world, is absolutely irrelevant to whether they should be incarcerated or not. In other words, if you as the judge deciding a case believe that there are some conditions you can place on a person accused of a crime's liberty that would reasonably assure public safety or reasonably assure their return to court, then you should do that. And their ability to pay cash is rarely, if ever, going to be a relevant factor. If there's no conditions, then you should make a transparent detention order in order to protect the public and ensure that they come back to court. But if there are conditions, then you should impose those non-monetary conditions. What we did in San Francisco was essentially just that. We, my first month in office, prohibited my assistant district attorneys from ever asking the court to impose money bail at arraignment. We ask for detention in cases where we think there's a serious flight risk or public safety concern that cannot be mitigated. And in all other cases, we ask for appropriate conditions sufficient to mitigate our concerns. We articulate what those concerns are. And I want to emphasize one last point that I think follows up on something that Robin said. It is really important to remember that the vast majority of people who fail to appear in court in the United States are not flight risks in the traditional sense. They are not people who have fled to Mexico or Australia. They are people who forgot to go to court for a variety of reasons, usually related to mental health, substance use, the fact that many of these individuals are unhoused and don't have a regular calendar or cell phone. If we can provide them with reminders, with transportation to court, it is far more humane, far more consistent with our constitutional protections, and far more effective ultimately than using a wealth-based detention system.
Thank you. And along those same lines, let me turn to Ms. Steinberg. You founded the Bail Project, and that seeks to provide bail money to those who can't pay their bail. I've heard you say that freedom should be free, and you've been working hard to take that across the nation. Can you tell us a little bit more about how the Bail Project works? And then, is that a solution or is it just a starting off point?
Thank you. So the Bail Project is a national not-for-profit organization, not-for-profit being the key phrase here, which is really important because I completely agree with our previous speaker that money has no place in our criminal legal system and private industry shouldn't be in it. But we're a national not-for-profit with 23 different sites across the country, and we have 3 core components to our work, right? So one is that we do direct service work, meaning we provide a lifeline for folks who might otherwise have to stay in jail because they don't have enough money to pay their bail. We pay their bail using philanthropic dollars. So we pay people's bail using money that's been donated to our National Revolving Bail Fund. We use that money to pay people's bail, knowing that if they come back to court, that money will revolve back into the fund. So the fund can actually sustain itself as we pay bails one person at a time. There's no fee attached to it. The person whose bail we're paying doesn't pay anything to anybody. So it is literally just taking the philanthropic dollars, paying the bail, and allowing people to be free when they're fighting their cases. So that's the one part of what we're doing. The second part we do is we provide supports, right? So once, very much like the District Attorney Boudin was just saying, once we pay the bail, right, there are lots of things that people may need to ensure they come back to court. So one of the things we do is we send court reminders, right, text messages and court reminders to clients. We connect folks to services they may need. For some folks, it's basic needs and basic things that actually everybody should be getting access to, but may need to have the connection to social services to support them. And we try to problem solve what obstacles might get in the way to coming back to court. And it could be anything from lack of transportation, It could be you have a boss who says, if you take one more day off from work, I'm going to fire you. And somebody's faced with that decision about feeding their family or going back to court. And in that situation, people will do whatever they have to do to feed their families. So we provide those supports and connect people to services. And then the third component of our work is that we are collecting the data to really better understand at a national and local level what's happening, what gets in the way of people coming back to court. Do people come back to court? And then we're using that data and the human stories about the devastating consequences of being held in pretrial detention to work towards bail reform and advocacy. We've done about 12,000 bailouts since we opened in January 2018. Nationally, clients are making 91% of their court dates. What's also really interesting to see is from jurisdiction to jurisdiction, case dismissal rates are anywhere from 20% to, in some jurisdictions, as high as 56%. Once we pay bail for somebody, cases wind up getting dismissed. It tells you a lot about policing and over-policing and over-criminalization of race and poverty in this country. And we're able to also look about what services people need, what gaps there are in various jurisdictions in terms of infrastructure to provide for folks that are going through the criminal legal system. Our work is really designed to prove that you don't need money bail and that you can just release people to their community, give them supports, connect them to services, and give them really realistic court reminder systems. And people will come back to court the overwhelming amount of time, and that it's a viable alternative to our cash bail system. And of course, the other thing that we look at is, you can't talk about racial injustice in this country without talking about the criminal legal system. And that's true from every single stage of the criminal legal system, from how we define crime to who we police to how we police. But it's also true in terms of cash bail and how bail gets set. You alluded to this in your opening statements, Judge, that if you are Black or brown, bail is more likely to be set. It's more likely to be at a higher amount. You are less likely to be able to pay it, which will wind up meaning you're going to plead guilty to go home, giving you a criminal conviction, which will create barriers for you and your family for the rest of your life in a sort of perpetual punishment cycle. So that's the work that we're doing. And we think the work that we're doing and the results that we're seeing are very much proving that cash bail should be eliminated. It is not a solution. Bail funds are not a solution. Our national revolving bail fund is not a solution. Any bail fund is not a solution. It is a tool that we're using while reform efforts are hopefully marching forward. It is a tool to provide an immediate lifeline. It's a tool to prove the point that you don't need cash bail to make sure people come back to court. And it's an effective tool, and it disrupts that moment at the front end and prevents incarceration before it begins, disrupting the cash bail system, disrupting the criminalization of race and poverty, but it's not a solution. It's just a very powerful tool for us to use right now as we hopefully march forward to bail reform and eventually the elimination of cash bail.
Thank you. Let me turn back to Chief Magistrate Mary-Louise Hribal. What role does money play? Because you said that there's about 100 people that have money. Is that something that stops people from fleeing and gets them to return to court? And I also think I read about a guarantor. Who is that?
Sure. The role money plays is that often if a judicial officer is considering whether or not to grant bail and they have real concerns about whether or not someone is a flight risk, it usually relates to that aspect of your concern. Cash is often proffered by the defence. It's usually not something that is a conversation initiated by the judicial officer, but you might be told that they're prepared to offer $20,000 or 2 lots of $20,000 or deeds of a house. They're the sorts of amounts of money, not the sorts that we often hear coming out of America, which are, often very substantial. So that's the role it plays. It would be taken, it would be put, the court would hold it, and then it would be returned in full, provided the person returned to court. I just want to follow up on something that Robin was mentioning. We found that text messaging to remind people to come to court is extremely important, and a number of our courts send those text messages out to the defendants. You also talked about services to try and assist people and remind them and hook them into either mental health or drug and alcohol services. That role is actually played in our system by the Department of Correctional Services. So you can actually make a bail condition that someone is under the supervision of the Department of Correctional Services while they're on bail. They will be assessed and determined at what level the service is provided to them. So they might be seen weekly, they might be seen less often, but at that point they might be hooked into either some mental health services or some drug and alcohol counselling at that time. So they provide that service. They don't provide a transport service to court, although there are some non-for-profit organisations that might assist defendants in that regard. Guarantors is the idea that you can order that someone be a guarantor. So if you're going to release someone on bail, you might set their bail at $1,000, but that, or $500, that's a figure that's not payable unless they do not turn up, in which you can make an order that that amount be estreated. The reality is that for most people, you're not going to recover that money. If they've disappeared, then you're not going to get the money from them at all. But you can decide that you're going to order a guarantor. It has to be a suitable person. It's got to be someone who generally is known to them, who isn't themselves facing criminal charges, and who agrees that they will get them to come to court. So it's more, they provide more of a reminder service to them and assist them. There's a cash amount that is attached to the guarantee. They don't have to stump up that money, but if the defendant doesn't attend court, then the guarantor is liable for paying that money as well. But once again, trying to get the money out of the impecunious is, sort of not likely to work. But it's something else. And if you've got a young defendant and they've got what appear to be responsible friend or a relative, then a guarantor might be something that you might consider as a way of trying to get them to return to court.
Thank you. I think that kind of leads right into my next question. I'm going to direct this to Chief Probation Officer Seale. We've heard about supervision. I know you have a pretrial program there. Can you tell us how that's run, and are there assessments involved in deciding what the supervision level is going to be?
Yeah, thank you. We were one of several counties in the state of California that received a grant through the courts to launch a pretrial system. We've done that. It began in about October of last year. So we've really focused on the last 8 months or so, bringing it up, making it operational, figuring out how to shift away from cash bail with a diverse set of stakeholders, including our sheriff and our district attorney's office, the court system, all of our system partners. And, it's going well, unquestionably in my mind. We have nearly 450 people currently out in the community as part of our program. The way it works is such that I am 100% confident that those are people who otherwise, in fact, would be incarcerated absent our program. So we really do see that as a net impact on the system. It's significant. And it's particularly significant right now because, as we may talk about in a moment, many of our jail populations are already declined as a result of active measures that stakeholders have taken to reduce those populations. So for us to continue to scrape an additional population out of that and reduce it further, I think is significant. We utilize a team of people, including sworn officers and non-sworn staff, to do everything from try to connect people with services, reminders, as we've talked about. Those are absolutely key. It's common sense, but you can never repeat that enough, how important that is. But also sworn officers at kind of the other end of the spectrum, in event where we need to get a hold of somebody, locate somebody, or in what have been relatively rare instances, make an arrest and take someone back into custody. But I'm pleased to report that that happens quite infrequently. We do use a risk assessment as part of our program. It is the public safety assessment that was referred to earlier. I will tell you up front that I'm not going to die on a hill of defending the use of risk assessments or any particular risk assessment. I'm not going to tell you that they work perfectly, because they don't. I'm not going to tell you that they have some special power. They don't. They give us a little bit, in my view, a little bit more information than we have without them, but they are not a panacea. And if the voters or lawmakers decided tomorrow that we were to operate without a risk assessment, we would continue with our program with no problem at all. I will say this though, I think opponents of SB 10 try to pitch the use of these words, future prediction and algorithm, and it conjures issues of Minority Report or something, and that's terrifying to all of us. But really, when you go see your doctor and your doctor asks you, wants to know about your cardiovascular health and asks whether or not you smoke and are you exercising and how's your diet and let's look up your age and, are you doing these things to take care of yourself? That is a risk assessment. And yes, that's also an algorithm. So the idea that we somehow shouldn't gather information and make it part of our decision-making is in my mind absurd. The legitimate question is the particular algorithm we're using and the particular risk assessment a good one and a fair one? And does it help more than it otherwise harms? So, I think I'm not defensive at all about having that question asked of any particular risk assessment. I think we should. We absolutely, in our use of pretrial, I believe, should be committing at the very least to using non-proprietary risk assessments. And by that, I mean things that are not sold to us by companies that mask or fail to disclose what are the elements, the questions they ask, and how they're weighted. All of that, there should be no black box to this. All of that needs to be either open source or made clear to all the stakeholders exactly what information is being gathered and how is it being weighted or used. Beyond that, risk assessments should, in my view, avoid any socio-demographic information. Obviously, not talking about protected categories, but even things like whether or not someone is housed. We don't ask that question because we don't want to, by proxy, have something that basically acts as a substitute for cash, as a kind of way of us getting at someone's economic status. Beyond that, we also don't find that it's a predictor in any way of future dangerousness or whether or not someone's going to show up. So it's an irrelevant question beyond that. I think it's absolutely fair game. The system should be talking about what is the best use of risk assessments, whether we should be using them, which ones we should be using. It's also new that those of us who are using these tools should not be defensive about asking those questions. And frankly, we shouldn't be afraid to return to this every now and then and say to ourselves, if they're not working or if it's not the right tool or if no tool is the best thing at all, then we're happy to course correct and make those adjustments. And I think that's the whole role of having a pilot program, is to be able to look at those things and make those kinds of decisions.
Well, thanks. Let me turn to you, Mr. Clayton, because I know you've got some concerns about assessments and some internal bias that people may find. So what can you tell us about that?
Yeah, I've worked on this issue for at least 12 years under a former Colorado Chief Justice who said these are an unnecessary security blanket for judges. We ought to just get rid of them. I think we've gotten to the point now where defenders of risk assessment tools start off by saying that they're non-scientific and start off by saying they're just one more tool in the toolbox and they're just one more piece of information. The problem is they were posited as scientific and they purport to predict scientifically. There's no lodestar for departing. There's no moment when we say, oh, we want to depart from the risk assessment and that judicial discretion will somehow correct it. The idea that the Arnold Foundation Public Safety Assessment Tool is open has not happened, despite what John Arnold said. The error rate balance test has not been performed on. It was just performed on the Colorado Risk Assessment Tool, which found, guess what? Bias against defendants in protected classes. So I've been working on this issue for a very long time. We knew this was going to happen. We knew it wasn't a substitution. And as Ms. Steinberg said, I mean, really, we have to have case-by-case analysis. We have to have hearings. And, you know, regardless of whether money's in the system or not, these tools have no role, and they're not going to solve it. They haven't shown any to achieve any of the goals that we want, regardless of what side of the issue we're on, whether we want to decarcerate, whether we want to, you know, decrease crimes while on bail, or we want to decrease failures to appear. And in some cases, we've actually seen in South Carolina, in particular, areas where we've increased racial bias. So I I don't believe in it. And I think at the end of the day, for me, as a person defending the right to bail, I'd rather lose the recognizance than supervision and risk assessments, because I don't think the supervision is evidence-based either. Just because somebody presents a high risk doesn't mean that if we supervise them aggressively and deny, you know, other liberties, that all of a sudden we're going to get a better result. We may get a worse result because we're criminalizing behavior and supervising that wouldn't otherwise be criminal. So I'm not convinced that offender-based supervision and that risk assessment is going to help us get there. And I think the critical choice is, if we're going to have money in the system, is okay, you know, release or not. You know, you get an excessive bail and that's it. And I don't think these other things like supervision and risk assessments do anything but to erode the presumption of innocence further. And if you don't like money bail, submit the fact that even when we don't have preventative detention, we seek detention by saying this guy's dangerous, and the judge goes, oh, okay, I'll just set $150,000 bail. So I think from all sides, this is a bad move, and I think it's highly embedded in Senate Bill 10, which I think will ultimately be the reason it goes down.
Well, you know, that actually leads me to my next question, and we're running short on time, so I'm going to ask everybody to weigh in on this. As I alluded to in my opening remarks, it's been widely reported that the current model of bail disproportionately impacts people of color, and I think we'd be remiss not to address that. So I'd like to ask you each your thoughts on that, and if you agree there's a disproportionate impact, and how can we try to remedy that? Let me start with our Chief Magistrate.
There is no doubt that there are way too many people, Aboriginal people, that are currently being held in our prisons. Home D, as I said, has gone some of the way to being able to see that they're released on bail. More accommodation needs to be made available to them in the form of bail hostels, so that they can safely undertake bail out of the community, out in the community. More than that, I don't think I'd be interested to hear from some of the others as to what you're doing in that regard, because we certainly don't have all the answers in relation to that. As I said, they're grossly overrepresented in the judicial system, the justice system.
Ms. Steinberg.
Well, as I sort of said earlier in my statement, you know, systemic racism is obvious in every single part of our criminal legal system, right? From the very beginning, and how we define crime, and how we arrest, and who we arrest, and how we charge, and how we set cash bail, and conditions of confinement, and who gets on probation and parole, and who gets violated on probation and parole. Racism is present in every single stage of our criminal legal system, and we cannot look away from that fact. It is horrifying, and it is a perpetuation of a long, long history in this country of racial injustice, as this country, I hope, is finally beginning to actually reckon with. And so, you know, I think about cash bail as one of the threads, right? If you think about the entire criminal legal system as a tapestry, cash bail is a thread we need to pull at. It's not the only piece. You can't fix cash bail, right, and eliminate racism in our criminal legal system. That is going to take a lot more work. And even if you're looking at just the criminal legal system, you're going to have to pull at all those threads and reevaluate and look within and look without about how we can change our criminal legal system, and so that racial inequities and injustice doesn't continue to perpetuate itself and embed itself in one of our institutions that has been guilty of perpetuating it most obviously. When I think about even the risk assessment conversation we just had, you know, one of the things that people raise, and what's real about it, is the data that goes into those risk assessments that spits out an answer is data that has been historically riddled with systemic racism. And so who got policed and who got thrown into this system is what shows up in that data, and that's what goes into the risk assessment tools, and that's how you spit out an answer. So one of the reasons actually not to ever use those tools is because it perpetuates the same kind of racism. I just want to say one other thing when we talk about risk, because I think this is actually embedded in our ideas about race in this country, which is we talk about risk and risk to public safety as if the 12 million people that are coming through our criminal legal system every year are not part of the public, as if the 12 million people that are shoveled into our local criminal courts are not actually at risk when they are put into jail cells. And so we talk about risk in this really disturbing way, right? That fails to recognize that there's imagined risk on the one side that we're trying to predict, right? But that there is real risk that's verifiable, well-established, scientific, and factual about the risks to people in jail, to their physical health, to their mental health, to the risk of being killed in jail, the damage and the risk to their families, to their homes, to their jobs, to their employment, to their futures, to their entire communities. And so when we talk about risk and we talk about public safety in the context of our criminal legal system, we have to face head on what we're really talking about and think about how we have literally taken out of the conversation folks coming through the criminal legal system. And that is because it, again, is based in our ideas that are embedded in a system that has perpetuated racial injustice at its inception. And so we really have to, when we're thinking about how to dismantle these systems, be very, very careful that we are not recreating the same kind of racial injustice that we've had all along. And you run the risk of doing that when you create things like supervision algorithms and put people on GPS monitors that they have to pay for. Who gets that supervision? Who winds up on those monitors? All will again reflect the same kind of systemic racism that we have in our system if we're not really vigilant and really careful and look at every single lane in the criminal legal system with an eye towards that.
Thank you. Mr. Seale, what's your position?
Well, I think this is an absolutely right conversation to have. And, you know, as I said before, we have to look at the data and we have to look at the outcomes we get from using the tools. And we have to be very sober about it and be willing to abandon those things that the data and the evidence tells us are perpetuating the worst kinds of racism that we're all seeking to minimize, if not eliminate one day. You know, I think we're pretty good at identifying racism in the system, and rightly so. I think the trouble is you know, if you believe that you know, unconscious bias really unfortunately threads through all human decision making, then it becomes more difficult to say, you know, what is the data point that we're going to use that is free of that bias or somehow doesn't demonstrate and evince those same issues that we're trying to stay away from. So I think the question, you know, I think it really is incumbent on us as we pilot and experiment, and I'm a big fan of different models. It doesn't have to be law enforcement. It doesn't have to be one way. It doesn't have to be a certain model. It doesn't have to be a certain tool. It doesn't have to be any tool. Let's really let different jurisdictions look at different ways of doing this and let the data speak for itself. You know, those things that best take impacts based on race out of the system, those are the ones that we're all going to join behind and want to further utilize.
And finally,
Can I
go ahead.
Can I just jump in for a minute, Lisa, and just say, I just want to make sure that everybody realises that in my state, we don't pay for home detention. The defendant does not pay for home detention monitoring. So that is not a bar to people being on home detention. It is provided for them. So.
Thank you for that clarification. That's important. I want to give one last moment. Mr. Clayton, I see you raising your hand, so I'll give you 1 minute, and then I'm going to give Mr. Boudin our final moment. So go ahead, Mr. Clayton.
Thank you. I would agree that the academic research shows that minority defendants face a harsher system under the money bail system, but they also face a harsher system under the system of preventative detention, which during the crack cocaine disparity days and all of this made the situation worse. So ending money bail is not going to solve the problem. And of course, I don't think your right to bail should depend on who's the elected district attorney. And while The district attorney of San Francisco may like me, maybe one in rural Missouri wouldn't like me as much. And I don't like the flexible concept of that. I'd rather go with excessive bail, and I'd rather go with the right, with the question of sufficient surety. So I worry that we would replicate the system under preventative detention, and I don't want to turn over to officials in Sacramento or to district attorney policies to decide who's detainable and who's not. I think that's too vague for me. I at least want it to be in the Constitution that specifically delineates which crimes and circumstances that I'm going to be detained. Absent that, I just don't trust the discretion of public officials, and perhaps it's because I'm Scots-Irish. I just don't trust the state in general to be making those decisions, and I'll go ahead and stick with the right to bail. So thanks for having me. It was a pleasure.
Well, I will agree with Mr. Clayton on at least one thing, which is I think that who is even eligible for detention should be defined by, I think it is, if you look at California Constitution, Article 1, Section 12, it very clearly states who is eligible for detention. We're waiting for further guidance from the California Supreme Court on the interplay between Section 12 and Section 28 of that state constitutional article that will basically provide lower courts and district attorney offices with parameters. Against whom can we seek pretrial detention, and who must be released pretrial because the nature of the offense they're accused of is so de minimis. That's an open question under state constitutional law. It's one we're eagerly awaiting guidance from the Supreme Court on. But back to the core question that you asked, Judge, absolutely race plays a role in setting of money bail, and it plays a role in who pays money bail. The San Francisco Treasurer's Financial Justice Project did a report about 3 years ago. It was a deep dive at who actually pays the non-refundable bail premiums that fund all of the members of Mr. Clayton's association. And it turns out it's Black and brown women. It's mothers and girlfriends and sisters and daughters of the men who are arrested. And they pay, in San Francisco, approximately $10 million a year in non-refundable premiums that, as one federal judge here in San Francisco ruled, have absolutely no relationship to any legitimate government interest. But again, I'll agree with Mr. Clayton. Risk assessment tools are rife with their own risks and challenges. And we cannot simply charge blindly forward calling these tools race neutral because they don't explicitly factor race in to the algorithms, which again, as Mr. Clayton pointed out, we need more transparency, we need more information, and risk assessment tools, as Mr. Seale pointed out, can be a useful data point, but we cannot put them forward to the public as a panacea. They are not a panacea. They will not, as Ms. Steinberg pointed out, solve all of the problems of deeply entrenched institutional implicit and explicit racism that manifest at every single stage of the criminal justice system, with or without money bail.
Well, I want to thank all of you for your time and remarks. I knew an hour was not going to be sufficient. We could have talked for many, many more hours on this. I want to thank everyone who joined us to discuss this very important topic. We've heard that the disparities in our system are unsustainable. Everyone's entitled to equal access to justice and equal treatment under the law. And if, in fact, as we've heard today, we have a system where a person's availability of economic resources determines their liberty, or the price of that freedom is dependent upon the color of their skin or their gender, then there is a question whether that mandate's being met. And such a system would impact people's faith in the justice system. And so the question remains, how do we ensure people are treated fairly, that both the public safety and a person's liberty rights are protected, and that someone charged with a crime returns to court? As you've heard, it's a complex question, and again, one that we could discuss for so much longer. But I'm grateful we've had this opportunity to at least touch on a few of the issues. I didn't even get to COVID. I wanted to talk about that. But I think that we've hit on some really important issues surrounding bail reform. So thank you to our hosts. Thank you to our panel. Thank you to everyone who listened tonight. Good evening.
Thank you.